Welcome to the first installment of our series examining the stress points in American democracy. Today, we are looking at the broken bench, America's Supreme Court in the age of manufactured majorities, ethical collapse, and democratic legitimacy crisis. This is a study in institutional failure, political capture, and the future of the judiciary. This chart shows 5 decades of Gallup polling on public trust in the United States Supreme Court. For most of that half-century, approval remained remarkably stable. Then, in the summer of 2022, the number dropped to 40%, the lowest rating in recorded history. When Alexander Hamilton designed the framework for the judiciary in Federalist 78, he called it the least dangerous branch. It controlled neither the sword nor the purse. Its entire authority rested on the public accepting the wisdom and impartiality of its judgment. A loss of public trust at this scale does not happen overnight. The polling collapse is the measurable symptom of a much deeper structural failure, a crisis resting on 4 distinct pillars of institutional decay. The first pillar is a demographic accident. Article 3 of the Constitution grants judges tenure during good behavior. In the 18th century, when average life expectancy was under 40 years, that meant a Supreme Court justice served an average of about 8 years. This chart compares that founding-era baseline with modern service lengths. Today, a justice appointed in their 50s might serve 30 years or more. A single appointment now spans multiple generations, shaping the law long after the president who made the nomination has left office. Because the impact of each vacancy is so vast, political movements adapted. Organizations like the Federalist Society built highly systematic pipelines to identify, credential, and vet legal talent, guaranteeing that a president's nominee would reliably deliver specific ideological outcomes. What was designed as a mechanism to protect judges from royal retaliation is now functioning as a permanent partisan advantage. Lifetime tenure has turned the confirmation process into an intergenerational political weapon. The second pillar of this crisis is procedural. In February 2016, the sudden passing of Justice Antonin Scalia opened a vacancy that could alter the court's ideological balance for the first time in decades. Within hours, Senate Majority Leader Mitch McConnell announced a new rule. No nominee would be considered during a presidential election year. Judge Merrick Garland's nomination was held vacant for 293 days, with the Senate refusing to even schedule a hearing. 4 years later, Justice Ruth Bader Ginsburg passed away under the exact same constitutional circumstances, during a presidential election year. This time, the Senate confirmed Amy Coney Barrett just 8 days before the 2020 presidential election. The stated principle of 2016 was abandoned the moment it became politically inconvenient in 2020. By rewarding this procedural maneuver with multiple lifetime appointments, the Senate effectively dismantled its own confirmation norms, leaving naked partisan power in their place. The third pillar is ethical. In 2023, investigative reporting revealed that Justice Clarence Thomas had for more than 2 decades accepted millions of dollars in undisclosed benefits from a billionaire political megadonor. These were not minor oversights. The gifts included hundreds of thousands of dollars in private jet travel, international superyacht voyages, real estate transactions, and private school tuition payments for a family member. This behavior exposed a massive structural loophole. Every district and appellate judge in the federal judiciary is bound by a strict, enforceable code of conduct. The Supreme Court is expressly exempt, operating entirely without mandatory, externally enforceable ethics rules. This lack of independent review extends to recusal. Following the 2020 election, Justice Thomas's spouse actively sent messages to White House staff urging efforts to overturn the results. Yet when cases directly related to the 2020 election reached the Supreme Court, Justice Thomas unilaterally declined to recuse himself. The Supreme Court is the ultimate authority on federal anti-corruption laws. When a court permanently exempts itself from the basic ethical standards required of every other federal judge, it structurally destroys its own public credibility. The fourth pillar is doctrinal. The current court has begun aggressively dismantling established legal precedent, issuing decisions that stand in direct opposition to documented public supermajorities. In 2022, the court's 6-3 ruling in Dobbs eliminated the nearly 50-year federal protection for abortion rights. Polling consistently showed that 60 to 66% of Americans explicitly opposed overturning Roe v. Wade. This pattern repeats across multiple areas of law. The court has drastically expanded gun rights against heavy public support for regulation and eliminated Chevron deference, stripping federal administrative agencies of their power to regulate the environment and public health. In 2024, the court shielded former presidents with substantial immunity from criminal prosecution for core official acts, terminating a federal prosecution that a broad majority of citizens believed should proceed. When a judicial body systematically uses procedural advantages to deliver extreme doctrinal shifts opposed by vast majorities, it stops functioning as an impartial interpreter of the law and operates as a political actor in judicial robes. This transformation presents a critical threat to the rule of law because of a concept called legitimacy-based compliance. The Supreme Court does not have an army or a police force. It relies entirely on the public's belief in its fundamental fairness to see its rulings enforced. As that belief erodes, state and federal actors lose the incentive to obey the court's orders. If political branches begin treating judicial decisions merely as partisan moves to be ignored, the system faces an acute enforcement crisis. This chart illustrates the leading moderate reform to address the crisis: staggered 18-year term limits. Under this proposal, each president would appoint a justice every 2 years. This guarantees predictable appointments and completely removes the incentive for justices to strategically time their retirements. Other legislative proposals include expanding the number of justices on the court or using congressional power to strip the court's jurisdiction over specific types of cases. These are highly aggressive tools, carrying the real risk of a tit-for-tat escalation, where each new political majority simply overrides the last. But the debate over these proposals is no longer confined to the academic fringe. Restructuring the Supreme Court is now discussed as a democratic necessity to hold the institution to a standard consistent with the immense power it exercises. The analysis in this episode is based on Volume 1 of the book series, To Preserve, Protect, and Defend the Soul of America, authored by Sue B. Howell, which is available now on Amazon. To continue exploring the stress points in our constitutional system, please subscribe to the channel and press the bell icon to be notified when our next video is released.